trustee.
So what do you think prevailed upon that High Court judge on that Sunday, so that, you know, for him to hand out this ex parte ad interim injunction? And really, where do you think this case goes from here? Because he did that in order to stop what Unitech's promoters call could have been a catastrophic impact. But now when he hears this case at length, what are the arguments that he's going to take on merit?
See, the granting of an injunction is always at the discretion of the judge. And if the judge he's not going to give reasons when he grants an ex parte ad interim order. He has just simply said that there is a prima facie case, that the balance of convenience is overwhelmingly in favor of the company, and that irreparable loss would be caused to the company. These are the three things which are stated in the order, exactly the same things which are stated, interestingly, in the information memorandum of the company when these debentures were issued. So to that extent, it actually contemplated this possibility when the risks were enumerated in the information memorandum. It clearly said that this enforcement can be injuncted by a court of law provided these three criteria is satisfied. And the learned judges come to the conclusion. These, I think, are standard requirements for any injunction, right? Yes, that's right, for the exercise of the discretion in favor of granting an injunction. So one would not obviously like to comment on why judicial discretion was exercised in the facts of this case. However, going forward, if this results in a judgment, because ultimately the suit seeks a permanent injunction. In this case, it might be resolved because, as you just said, 50% of payment is made, and maybe the balance payment. That's what Unitech said in their response to us, that we've already repaid an amount of 89 crores, which is 50% of the outstanding amount, and intend to repay the balance amount much before the timeline set by court. As of date, lenders have a security cover of approximately 4 times, which is much more than, of course, the mandated or the required 2.5 times. The point I'm making is that just like in bank guarantees, when you give an irrevocable bank guarantees, in the earlier days, a lot of courts used to interfere with an injunction order until the Supreme Court and some of the High Courts said that you can only do so if the irreparable injury or fraud was the result of the invocation of the guarantee. And thereafter the courts have been very circumspect in granting an injunction order against the enforcement of a irrevocable bank guarantee. This is a similar situation. Forget the facts of the present case. If this becomes the law of the land, or if these type of episodes are repeated, where the promoters in such a situation rush to court and obtain an injunction, what is going to happen is that it's going to shake or erode the confidence or faith of the investors in this form of promoter financing and dry up the market. Okay, one question in the inherent contradiction that probably will, sort of get argued upon as this becomes a full-fledged case between what is placed in the share pledge agreement and what seems to be the law as we know it. The share pledge agreement clearly says that if an event of default occurs whereby the stock price drops by 40%, or there are 2-3 other such situations that they lay out, the debenture trustee is empowered to immediately and without reference or notice to the pledger dispose of the collateral by sale or otherwise, etc., etc. Elsewhere, it also says that the debenture trustee can in fact do this without any, needing any recourse to the court, or without even, seeking the court's permission, so to speak. Now, that's what the share pledge agreement says, and Unitech's promoters have signed this share pledge agreement agreeing to it. Yet, in their complaints to the Delhi High Court, they brought up the question of Section 176 of the Contract Act, saying, but that requires you to give us reasonable notice before you sell collateral. On the one hand, you're saying you don't need to give us notice. On the other hand, you're saying, but the law says you need to give us reasonable notice. How do you reconcile this? Well, as we all know, it's a cardinal principle of law that a statute always prevails over a contract. Right. And the promoters of Unitech are indeed right when they say that whatever they may have agreed, you cannot contract yourself out of the statutory protection which the law accords to you. So to that extent, it's a correct argument that a notice had to be given, and the trustees therefore did give a notice. So this clause in the share pledge agreement is actually, what is the word, malified or bad or wrong? The argument which is made over here is that this particular clause is violative of Section 176, and therefore it is unenforceable. Right. So to that extent, they are right. The question over here is that in future contracts of this nature, a clause will have to be inserted as to what is deemed reasonable notice, and if that reasonable notice is given, then this argument can be preempted. So in a situation like this, a trustee would give a notice say for 24 hours or 48 hours.
Does the Contracts Act say anything about what is reasonable notice?
No. It depends on the facts and circumstances.
So now this is down to the discretion of parties who are contracting?
No, it depends on the facts and circumstances of the case for the court to decide what is reasonable notice or not, commercially.
Alright, so investors are going to get spooked, and from here onwards share pledge agreements, the few of them that will get signed if this continues are going to have to build in requirements for a reasonable period of notice.
Yes, because it's the occurrence of the episode which is the catalyst for this apprehension. Because this, as I said, this matter is most likely going to be resolved. So you are never going to get a judgment on this issue at all.
Sure.
Which is even more undesirable in the sense that this might encourage other promoters who have done this type of promoter financing, and there are a lot of such instruments floating around in the market. So if this happens again, the tendency to rush to court to buy time and then to settle the matter on better terms.
It's not a very bad outcome because they're paying it all back in the course of 1 month. So really the investors are not out of pocket in any fashion.
I don't think that the investors will be very happy with this. When you strike a bargain, you stick by the bargain. If you are feeling so apprehensive, don't pledge listed shares.
Alright, Berjis, thank you very much for all those comments. I'm going to, before I take a quick break, ask Mr. Vasani. I know that you choose not to comment on specific matters, but you heard the principle of the case here. What do you make of the developments and what impact? Berjis says it definitely doesn't bode well for promoters wanting to raise money this way.
Well, as I told you that I'm not fully familiar with the facts of the case, and since the matter is sub judice, but I'm not as worried as Berjis is, because all interim injunctions are granted in the context of the facts of this case, and whatever limited facts which are available in public domain, it does seem that a judge did see that the requirements of Order 39 of the Civil Procedure Code, which deals with grant of interim injunctions, are fully satisfied. As I told you, there are 3 cardinal principles. There is a prima facie case to grant an injunction.
Balance of convenience.
The balance of convenience and also irreparable loss.
Right.
And I suppose that from the facts which are presented so far, it's very evident that all the 3 criteria were met, and it's an interim injunction, it's ex-parte interim injunction. In fact, as per the Civil Procedure Code, it needs to be confirmed, and as I told you, it's not a judgment as yet. So it's premature to comment on it, but I don't think that this particular interim order will help other promoters to rush to the court, because here it seems that the promoters have volunteered to pay up the amount, and so in my view, I don't think it will have a very significant impact on any of the future promoter financing transactions.
Alright, gentlemen, thank you very much, Berjis, for commenting on this, and Mr. Vasani for your comment. We're going to take a quick break, but we're going to come right back with an equally vexed issue, in fact even more so, and this has to do with call and put options. The big question is, are they legal or illegal?